Hi there. The Supreme Court is back. Justice Ketanji Brown Jackson is on the bench for the first time. Public approval of the court at historic lows. The nation's top court set to consider some controversial cases that could change the course of free speech, affirmative action, and voting rights. So what can we expect to see this term, and which cases should liberty lovers keep an eye on? Joining me to discuss, Cato Institute research fellow and managing editor of the Cato Supreme Court Review, Thomas Berry is back. Welcome back, Thomas.
Thanks for having me.
So the court has a 42% approval rating. Does that matter?
No, it's certainly lower courts, circuit courts are not going to be looking at the approval ratings and deciding whether they really need to follow the Supreme Court or not. Its decisions are binding, and there's no sign that any lower court or that anyone who matters, who has to follow the Supreme Court's decision, is going to be any less likely to do so based on opinion polls. It could affect the upcoming election. It could affect who gets elected and who selects future justices, but it's not going to affect the binding nature of the opinions they have handed down and will hand down.
All right, so let's talk about some of these cases. You have two cases that look like they're being bound together involving Google and Twitter and Section 230. There are a lot of people who really want to stick it to these giant tech and social media companies, but will they regret what they're wishing for?
I think they may well. Section 230 comes down for a lot of criticism. In a nutshell, it says if I tweet something very slanderous about you, you can sue me, but you can't sue Twitter. This case that the Supreme Court just granted says, okay, but what if my tweet is so hilarious and gets so many likes that their algorithm puts it at the top of everyone's feed and shows it to everyone? Then could you sue Twitter for amplifying my slanderous tweet? If the Supreme Court says yes, it's going to change basically the way every website operates. If they can't have algorithms tailoring what they think you're going to be interested in and what people are more likely to see, the internet as we know it is going to change, and it probably become a lot less user-friendly and show you a lot more stuff that isn't relevant to you.
That's really interesting, because you know what you're saying right now, that is how TikTok and Instagram make money. Instagram has changed its entire model, so they're basically like an adult version, not like XXX yet, of TikTok, where they push reels that you might want to see to the very top of your feed, and you don't really have that much choice about it. You just, you know, in a coma watching these things. And you're saying that if the court rules in favor of sticking it to the companies, that's not how things will be moderated in the future.
Yeah, companies may well not be able to moderate at all. They may give up on the business of having these algorithms, and the business model as we know it isn't going to function anymore. As much as people like to mock these algorithms and complain about how they're brainwashing us, they also result in people finding a lot of more stuff that's relevant to them than they otherwise would, especially if you think about something like Google that people use on a daily basis to find information that's relevant to them. It's really uncharted water what would happen if Google wasn't able to tailor results that they thought were most relevant to its users.
All right, let's talk about Sackett versus the EPA. How should the court rule on this? A family, they had a home under construction in beautiful Priest Lake, Idaho, where I learned to water ski, and the EPA ended up finding them tens of thousands of dollars a day because they weren't properly permitted by the EPA because, you know, navigable wetlands are somehow forbidden territory. How should the court rule on that?
Yeah, this is a really Kafkaesque case that's been dragging on for 16 years since they wanted to start construction on the home that still has not been built. The court needs to draw a bright line so that people know what's in water of the United States, that's a statutory term, and what's not. The EPA wants a rule that says any marsh or swamp or puddle on your lawn that may be part of the same ecosystem as another water 30, 100 feet away, separated by a highway, could still be subject to their jurisdiction. If that's the rule, no one's going to know in advance, and everyone's going to have to litigate it. I think they should side with Sackett, who wants a bright line rule. If your water is actually connected to, in this case, the lake, the river, the stream, the thing that's obviously water, then it's regulable. So then people can simply use their own eyes to know whether they need a permit or not.
Absolutely right. And, you know, it is logic, and it goes in the face of Chevron deference, correct? Where
absolutely, the
federal
EPA has been
agency can just go,
relying
we
on
can
it.
do whatever we want. And a lot of Supreme Court justices are like, yes, Chevron deference, we'll let you because we're dumb. Well, I'm with you on the Sackett case. There are many other interesting cases coming up, and we will rely on you in the future. Thomas Berry, thank you so much.
Thanks for having me.
Yeah.